Good morning. My name's Adam Haynes. I'm an employment partner at Aaron & Partners, predominantly based in our Manchester airport office, work also from Chester. I'm joined today by my colleague Ikram, who's a business immigration specialist, and he's going to be doing the majority of the talking, thank God. So Ikram, over to you.
Thanks, Adam. Yeah, and good morning, everyone, and thank you for joining us. Now, what we're going to be covering is employing skilled workers from overseas, and mainly the requirements of getting a sponsor license. Now, we've had some questions that have come through, so Adam's going to help me out and pose those questions to me, and I'll be answering those. If with those questions, if you have any of the questions that come up, feel free to put them in the chat box, or feel free to speak again, and then at the end of the questions that we've already had, you can ask those questions. So over to you, Adam, the first question.
2 seconds. Just give me a second, please. Ikram, just give me a second.
Sure.
Here we go. Sorry about that. Normally I write them out, but you sent them through an email. The email went missing. So, so sorry about that. Right. So the first question we received is that we have a number of EU nationals working for us and are considering applying for a sponsor license. Could you explain the process and the estimated timeframes for putting in place a sponsor license?
Okay. Absolutely, yeah. So the process itself is submission of an online application, which is completed providing the details. Now, with that online application, you've also got to provide information as to the case as to why you are applying for a sponsor license. So it's actually the business's need for the sponsor license, and what the Home Office really want to assess is there a genuine vacancy? Is there actually a need for applying for a sponsor license? Because they don't want to just give out sponsor licenses to businesses without there being an actual need. The process itself, once from that submission, it takes 8 weeks to get a decision if you use the standard process. And with that, what you have the option is that once you have submitted your application, you are looking for a quicker decision. You can book a priority service. Now, they give 10 priority applications a day, so they approve 10 priority applications a day, and you can pay an extra £500 if you want a decision within 10 working days, and that's 10 working days from the acceptance of your priority request that you would put in. So once I'll go back now. Once you've sort of submitted the online application, you're required to provide mandatory documents to them to establish that you are a genuine business. So they have a whole list of documents that you're supposed to provide. And again, the key information that I sort of highlighted, there's some information that you've got to provide to them to put that case forward. What you've also got to do is be careful in terms of choosing the key personnel for your sponsor license. Now, what you have is 3 roles that you would initially nominate as part of the sponsor license application. That is, 1, your authorizing officer, who then ultimately has the key responsibility for the license. Now, I normally advise that it should be a director or somebody really senior at that level. The pure reason for that is there are consequences, and in terms of responsibility, the ultimate responsibility of that management of the sponsor license, if anything goes wrong, it lies with the authorizing officer. So, for example, if something's not managed appropriately and there are sort of breaches within that license, the authorizing officer can face heavy fines, and in extreme sort of cases, there can also be a criminal conviction and imprisonment. So you have to be very careful in choosing the right personnel. The second role there is then the level 1 user. That is somebody that would have the ultimate responsibility of reporting your duties, and any change of circumstances onto the sponsor license. So again, somebody fairly senior, somebody who's not going to change their role very quickly or leave the organization, because they actually have the access to the portal. So they are the ones who are responsible for applying for certificate of sponsorships. And as I said, also reporting certain duties. And finally, your key contact, which again can be somebody from within the organization, or can be a representative or another person that you wish to nominate. And their role would be to liaise with the Home Office on any questions and issues that you would have.
Thank you. Just if anybody has any questions or wants to interject and get clarification or anything, please do. We've got quite a small group today, so we can quite easily open it up. Just one thing you said there regarding to the authorising officer point, is you mentioned there is consequences, but is it one of those things that is there as a potential threat but never actually utilised, or is it actually something you come across? Do you actually get people saying you're being investigated as a consequence? Or
sorry, I'm just going to stop the fan for a second. It's too loud and I can't hear you very clearly. So just bear with me a second. I just missed that, so just bear with me a second. Sorry.
Sorry. It's like Laura and Hardy today.
Sorry. Yeah, the joys of hot weather. But then we complain. Sorry. Go on. Do you want to repeat that? Sorry.
So just you mentioned about the authorising officer potentially. There's been consequences for the authorising officer. But some of the time with these type of legislations and restrictions, they have those things in place, but it never actually is looked into, or it's rarely looked into. It's only in extreme circumstances. Is it something you actually come across? Is it quite common, or is it quite rare?
Yeah, I mean, there's been a few examples. So again, it's only going to happen where there are breaches and where the duties aren't being performed. Now, they may get caught out earlier on, or even when you make an application, it can happen. But what the Home Office tend to do, the sponsor license casework team at the Home Office tend to do is that they will have visits. So once you are granted a sponsor license, and it's normally granted for a period of up to 4 years, they have their own audits. Now, you may be sort of lucky and then not have any audits for the first whole duration of full license, but you renew it and you may have it. There are examples where somebody's applied for a sponsor license and they've had a check come through within their first year of having a sponsor license. The key thing is what they want to be sure of is that you are familiar with your duties and that you are complying. Now, that's the big part of actually having a sponsor license. It leads into sort of a wider discussion because very much so it's not just a case of applying for the license itself, it's being familiar with what it sort of entails in the wider scope of things. So again, knowledge of immigration law, which is all changing all of the time, and again, your duties, compliance, and employment laws, as you know, so you're an expert. And I'll give an example a bit later on when we're talking about compliance on how that can impact. So yeah, the Home Office are quite sort of active in making sure that compliance is carried out.
I hadn't realised there was an audit, so yeah, that makes sense. So next one is, what are the main costs that we're likely to incur when applying for a sponsor license and employing an overseas worker?
Okay, yeah, so your main costs at the stage of when you're submitting that online application is if you are a small business or you are a charity, the cost is £536 initially for the license. If you are a medium to a large business, the cost is £1,476. So that's your initial cost of applying for a sponsor license. Now, again, as I mentioned, so that's granted for a period of 4 years. So then if you are looking to then sort of recruit migrant workers, the first cost that you are then required to pay at that particular point is the immigration skills charge, which for a small company or a charitable organization is £364 per year. If you're, again, a medium to large business, it's £1,000 per year. So it depends on the duration you're looking to sponsor the migrant for. If you're sponsoring them for say, a period of 3 years initially, if you're offering that for up to 3 years, you would pay the cost for 3 years. So it's either 364 times 3 or £1,000 times 3. And then you have the certificate of sponsorship assignment fee. So you have either the £199 that you would pay for a skilled worker if you were looking to assign a certificate of sponsorship to them. There is an exemption to that if you are sponsoring somebody from the EU or you're sponsoring somebody from Turkey. So the cost assignment fee of £199 is exempt if you're offering that sponsorship to them. I think we've seen a hand come up from Laura.
Hi, Ikram. Thank you for that. I'm not going to put my camera on because I'm not work ready. It's an annual leave day today, and I've been with the kids in the garden. I may have flashed up briefly when I came on, but the camera went off. So if you're okay just with my voice, please. Thank you for those costs. We're a multi-academy trust. Would we fall into the small stroke charity? We're sort of public sector, but obviously we're considered maybe medium to large sized organisation. Do you know where we would fall?
Yeah, sure. So I'll explain. So if you are, of course, if you're registered as a charity, then you'd naturally fall into that. But a small, for the purposes of Home Office, is if you're employing 50 or so you have to meet 2 of the 3. So if you're either employing 50 or fewer employees, that's one. The second criteria is that your annual turnover is 10.2 million, so less than 10.2 million. And finally, the total assets are less than 5.1 million. So any 2 of the 3, if applied to the organization, you would fall into the small business category. If the 2 don't apply, then you are either a medium to large organization.
Right, yeah, I think we'd be classed as the medium to large, so thank you for that.
Good question, and also good knowledge. I'm quite impressed you recall that from memory. So third question is, can we apply for a sponsor license now, even though we intend to recruit later in the year? It's a 2-part question. And what, in your opinion, are the advantages of applying for a sponsor license? So if you deal with the first one, do you want me to repeat it? And
yeah, please.
So first part is, can we apply for a sponsor license now, even though we intend to recruit later in the year?
Okay, yeah, yes, of course. So yes, you can. I mean, the simple answer is yes, you can. But again, as I mentioned at the start, so when we were discussing the process, it really is a case of, making a case when you're putting that application in as to why you need the sponsor license. So what you are convincing the Home Office or the sponsor license casework team essentially is that there is a genuine need for the business to employ either migrant workers from overseas or, again, workers that are currently in the UK. So there is a genuine business need. So what I would recommend at that particular point is, of course, setting out the recruitment plans. So if you already have one in place and you're looking to do that at the later end of the year, so when we are putting that application in, that's something that I would normally include and put that case forward. Because normally when you're applying for a sponsor license as part of the process, what you also apply for is what are known as undefined certificate of sponsorships, and excuse the sort of legal terminology, but they are sort of certificate of sponsorships that you apply at the time of making the application. And if you're applying for any of those certificate of sponsorships, you have to then provide specific information as to who the migrant worker is and how many of them you're expected to use, what the role is, what the salary is going to be paid. So all of that information has to go in. So if that's something that you've already identified, but you're looking to sponsor somebody later on in the year, then that's information that you would disclose to show that there is a genuine need for the business to employ. But it's obviously going to be a bit later on. But again, I think going away from that, it is a good idea to sort of apply early. As I explained earlier, it can take up to about sort of 8 weeks to even then get your sponsor license. So once you've got your sponsor license, you've then got to go through the process of then sponsoring the migrant itself, which will obviously naturally add time. So if that plan was even later in the year, we're now at the sort of end of July. So if you think that you're putting your application in now under the standard process and not the priority service, you're looking at a decision sort of at September time already, if you were to sort of apply now. So yeah, most definitely applications can be selected.
Okay, so then that ties in with, I think your point you just made is the next part, which is what are the advantages of applying for a sponsor license. So I suppose if by doing it now, it obviously saves time based on what you're saying, and also due to the complexity, I suppose it's an element of training and understanding and ensuring you know what you're doing. Is that?
Yeah, absolutely. So I mean, in terms of the advantages that you've got is, of course, the time factor. So applying early is, of course, one of the key things that at that particular point, if you've then identified a candidate or somebody has applied for a role, you're not then going through that process of the application and waiting 8 weeks, because what you then have a risk of is losing that candidate to somebody else. But I think some of the other key advantages that I sort of highlight in having a sponsor license is that it opens up sort of the doors for business to employ from a wider market. So, you're potentially opening yourself up, and rather than being restricted in a geographical area or just limited to just British citizens, EU nationals that are already, under the EU settlement scheme, or other people that are residing in the UK with sort of, indefinite leave to remain, what you are sort of opening yourself up for is, if you have a sponsor license and you've sort of advertised a role, and I've just recently had an example of this, I was talking to a business and they were saying that we're not seeing a lot of applications come through from graduates. And they are sort of, even the ones that are applying are looking for sort of part-time positions. Now you have a lot of overseas students who comes into sort of UK universities that are graduating every year. What they tend to do is that they will always go online and check the register of sponsors for somebody who has a sponsor license. So if they see a job advert and find that you're not on the register of sponsor already, you're not going to see their application. So potentially you're missing out on some really good candidates that are from overseas. And again, what you also may find is that somebody who's already working in the same profession for another employer, has been sponsored, is looking to sort of change their job. But if you haven't got a sponsor license, again, and they see a job role come up, they know that switching practically over is going to be difficult. So there are those sort of key advantages of being able to sort of attract a wider sort of from a pool of applications that would potentially apply for it.
Thanks, Ikram. Just out of interest, if anyone wants to drop a response in the chat, but a lot of the businesses that we've been speaking to are really concerned about the great resignation that's been discussed and a lack of skills shortages, a skill shortage within the UK at present, and companies risk assessing the possibility of a huge loss of staffing. So we're thinking of maybe doing something on that at a later date. So we're interested in people are finding that or worried about that, or if it's something that is just been sort of dragged through the media. Next question is, what requirement does a candidate need to satisfy to secure a work? Because again, this is a two-part question. So to satisfy a work permit, and then can you work for someone else if you're sponsoring them? So first off, what does a candidate need to do to secure a work permit?
Okay, yeah, so I mean, the terminology sort of work permit is sort of the old terminology under the new rules. It's something that I mentioned earlier, the certificate of sponsorships. So sort of good time to sort of explain that. So once you have a sponsor license, and if you are looking to sort of employ somebody under the skilled worker category from overseas, what you would be applying for, what you would be looking to issue using your sponsor management system is first you would request a defined certificate of sponsorship. You put that request into the Home Office request. That once that's been granted, you would then sort of complete the details of the migrant and assign the certificate of sponsorship. So that cost of £199 that I mentioned earlier would come in at that particular stage. Now, once that sort of certificate of sponsorship has sort of been assigned, what they are looking for in terms of the requirements for the migrant, they have to score 70 points. Now, those 70 points are scored with your first 20 points are for the right certificate of sponsorship that has been assigned, which includes the correct details. The second part is that the job that they are coming under is at the required and appropriate level. So that level previously used to be give level 6, which was the graduate level. Since, of course, Brexit and the changes in the rules in December, so 1st of December, they dropped that level down to level 3. So your A level or NQF equivalent levels, so the jobs are specified under which criteria they come under. The other 20 points are that the salary requirements have to be met. So previously, again, the minimum salary requirement was 30,000, which has now dropped to 25,600. And again, it's at the required level. Now, there can be variation in the salary, so there are sort of tradable points that you have got where you may be able to offer a salary below 25,600, and that's in particular cases where a job is listed at a PhD level, so you may be able to offer 90% of that. We also have a shortage of occupation list, so if the job that you're looking to fulfill is on the shortage of occupation list, you can pay 80% of that salary. And finally, there's a 70% for a new entrant. So if you have candidates under the age of 26 that are particularly applying for the visa, and the duration that they're applying for does not exceed the 3-year mark, they can be paid 70% of that salary. Now, I've made a reference to 25,600 as a sort of a benchmark, but it is the salary, either 25,600 or the salary specified in the occupation code, whichever is higher. So, for example, recently we were looking at chefs. Their salary that's specified is 19,000. But if you were looking to, so I'd advise the client that if you're looking to recruit somebody, they can't pay the 19,000, they have to pay the 25,600 because that's the higher mark. But say for another sort of a profession like a business development manager, the salary needs to be in the region of about £35,000 if you're looking to sponsor a migrant worker. So then at that particular point, you can't offer the 25,600. And then finally, the 10 points that you get after the 60 are 10 points for the English language requirement. Now that can be automatically satisfied if they are a national of a majority English speaking country, or they can sit a approved test, which is at level B1. So they have to pass the test, which is assessed in their reading, writing, listening and speaking ability. And IELTS is a common one that a lot of them apply from sort of overseas. Or finally, if they do have a sort of a qualification, which then the UK NARIC is an organisation here which recognises it to be at the appropriate level, they would issue a certificate and say the qualification that they have is at the appropriate level, so that English language requirement can be met. So you've got your 70-point certificate of sponsorship, job at appropriate level, the salary requirement, and English language requirements. So those are your main requirements. The second part I forgot that, Adam, could you?
Oh, terrible. So we've dealt with this previously with a client that we've had, because then we were working together on a contract for people. So I think I know the answer to this, but I don't know in the detail. So can they work for someone else if they are sponsoring them?
So if the business has sponsored a migrant worker, there are conditions. So yes, the migrant can potentially work have a second job, providing that it's in the same occupation code. So the code for the job, it needs to be exactly the same. That's the first condition. The second condition then is that they cannot work more than 20 hours. And finally, the hours that they have for that second job cannot conflict with the hours that are specified in the certificate of sponsorship. So if they are sponsored by you, they can't go. So if you've specified 35, say for example, 35 hours or 37 and a half hours, and in their job contract, those hours are say 9 till 5 or 9 till 5:30, then during those hours, the person can't work for another employer.
Yeah, and also from my perspective, from a due diligence perspective and compliance perspective, you just need to be mindful of the 48-hour working week, because obviously there's the working time regulations opt out, so you can't work above 48 hours unless you deliberately choose to opt out of those provisions. So just make sure you're doing that. And if there isn't an opt out, then you need to be alert to how many hours they're doing with their other employer. You don't want to fall foul of that. So yeah, just as something to be aware.
Just that you mentioned the client, you had to actually specify these provisions in the employment contract in terms of for them to be effective as well. So you had to sort of put special provisions into the contract.
Yeah, so what we did was we drafted the clause to say you won't work over a certain number of hours, and then require the employee in question to disclose timesheets or information as to the hours they're working. So therefore, if it was ever questioned in relation to how many hours they're working, we had clarification on that. And also we asked for the alternative is we asked for an opt-out of the 48-hour working week. Just as something to be aware of on that as well, is most contracts include a contractual opt-out. There is some uncertainty as to whether a contractual opt-out is sufficient or whether you need actually a letter of opt-out, which is just exactly the same really, but you just have a separate document that's signed in relation to that point and that point alone. Just from compliance and belt and braces, I'd always advise that you get a letter of opt-out, because there is uncertainty around the enforceability of sort of shoehorning it into a contract. So anyway, enough boring employment law, back to immigration. So do we need to show that we cannot find a suitable worker in the UK before offering the job to an EU national?
Okay, yeah, so the answer to that is no. That was previously a requirement. And again, the rules before the 1st of December 2020. Now, with the new rules, they've taken out the requirement of what was known as having to carry out a resident labour market test. So if the job wasn't on the shortage of occupation list, you had to carry out a resident labour market test, where you then advertised the position for 28 days on 2 forums. One of them was, of course, specified, was a government one, and you then had to list specific requirements. to make sure that you'd complied with the resident labour market test. Now, once you demonstrated that you didn't find a suitable candidate within the UK, you could offer that job. Now, the key change that has come through is that it's given the opportunity for businesses now to be able to choose the right candidate, the best candidate that they feel, and you can employ them from anywhere. So there is no requirement to do the resident labour market test. But what the requirement has sort of changed to is a genuine sort of employee requirement and then genuine vacancy. So the way you would normally, I would then say, still sort of show that it was a genuine vacancy and then this is the best candidate for the role, is that you are still then required to sort of show how you've identified that client. So if you have sort of, advertised the role, there are sort of record keeping duties in terms of what you need to maintain for having advertised it. If that person has been referred by somebody or, is known to you otherwise, then again, there are specific requirements to keep a record of that. So no, no requirement to show that you can't find the candidate, but again, the compliance element comes in where you are required to show how you've identified the candidate and you've got to keep a record of that.
So it's clear as mud. So just going back to that, is it possible for companies themselves to do these applications and also put in place a sponsor license? Is it relatively straightforward, or there seems to be a lot of intricacies to it?
Yeah, I mean, look, in terms of the application form, in all honesty, isn't the difficult part. So the application form asks for specific information. Even the mandatory documents are listed. So if you find the appropriate list, you can provide the sort of list forward. The key thing is that putting that case forward as to why you need it. And I think a lot of the times when I've been sort of doing webinars and other information, for me, getting a sponsor license or the actual migrant application is really 50% of the job done. The other 50% is understanding your role, your responsibility, and of course, compliance elements of it, which is the difficult part. And I often now find, and a lot of clients that we have sort of sadly had to represent is when they are then faced by a sort of a situation where there have been breaches of duties, where there have been breaches of other things. So one of the recent examples that I had is that the level 1 user sort of went on sort of maternity leave. Now, during that time, it would seem something like very sort of innocent that another colleague knew, the password and the login details. You don't think you're technically breaching anything. So they had, wanted to sponsor somebody. She was on maternity leave. Instead of having sort of another level 1 user appointed in time for it, somebody ended up using the details. Now, that in itself is a breach and then can result in a loss of a sponsor license. There was another situation that we had where the authorizing officer had sort of resigned and left. And because the company went active in using their sponsor license, they never changed that situation. So when they came around to actually applying for another migrant, it became apparent then to the Home Office that certain duties haven't been complied with or the role hadn't been changed. And again, they ended up sort of suspending their license, asking for questions, and it resulted in sort of revocation of their license, which meant that for another 12 months from their revocation, they weren't able to apply for a sponsor license. And it also meant, for the first one with the level 1 user, where the skilled workers that they had, the fact that the license had been suspended and they lost the license, those candidates had to be notified that they now need to find a job elsewhere. So in terms of the application itself is not the difficult part in dealing with it. It's making sure that you're fully aware of your role and responsibilities, really, and you're almost keeping up to date with the law. So one of the services that we do provide is sort of not just dealing with the application. We do account manager services where I'm now appointed as a recognized representative. I'm also doing sort of added as a additional level 1 user, where the company notifies me of any sort of change of circumstances or something that has happened. And I have to sort of, and then report those duties. So a common example these days, and I know we've got another webinar coming up on this on social media. So we know sort of, some things that go on social media can result in sort of implications. That's something that, again, the Home Office takes quite seriously. So the wider UK law is, a post on sort of, a social media, a comment can result in a loss of a sponsor license if, for example, it's made by like a level 1 user authorizing officer and there is action taken on it. They may even then choose, if they've identified it, to report it to the police. So these are sort of the wider things that really need to be looked at when you are, a sponsor license holder or when you're considering to apply for it.
So is that similar to sort of an overarching duty, such as like your Companies Act director's obligation? So you must act in the best interest of the business, you must is it sort of a status type?
Absolutely. So when you are completing that application, there is a sort of a declaration that you sign as part of the application process. And this is why, even though if I'm preparing an application for somebody, it would always be signed. So at the end, there's a declaration. So the online submission, I take the authorizing officer through it, but they sign their declaration and they actually submit the application online themselves rather than the representative submitting it because of the declaration. And in that declaration, you've got numerous things that are specified. And time again, people don't take the time to read those things out. But even if you haven't at that particular point, which you should, again, there's got to be a separate document that you've got to go and read and fully understand what your duties are and then what you must and must not do, really.
Thank you. And then we have one final question, which is, it reads as, I had a question around what to do if someone started a job on a dependent visa, okay, but has informed us there may be an issue with their spouse's visa. Can we apply to sponsor them in their own right in the usual way, as they have a sponsor license? We weren't sure if this would be frowned upon by the Home Office. So I think, first off, well, my first question would be, what's a dependent visa?
Okay. Yeah, I think there's this sort of, if the person's on, feel free to sort of clarify, because there are various different categories of a dependent visa. But the way I've sort of understood this is so if somebody had been sponsored by another sort of organization and they had their spouse or partner sponsors, so they would be here as a dependent in the UK. So it would be my understanding that the business are employing the dependent person, and it seems that the main sponsors now had an issue with their visa. So it depends, first of all, I think, what stage that issue is at, because if the curtailment has been issued, a curtailment has happened, then technically the partner's visa should also be curtailed at that particular point. So yes, it does sort of present a problem in itself if the visa has been curtailed. If the visa hasn't yet been curtailed, there will be a point where it will be curtailed. And by that time, so I think that the main question was that, can we sort of employ them? Yes. So again, with the changes that came through on the 1st of December, there were sort of a lot of positive changes. So switching from within the UK without having the need of returning back to their country of origin and applying from there, you can now switch, but you've got to make sure that switching is done in time and prior to their curtailment. Now, I'm going to cover another point as well, because the dependent visa could potentially be somebody who's here as a spouse, a spouse of a British citizen. They're still on a dependent visa. So if that was the person, the rules again similarly apply, because it won't be their partner's visa that will be cancelled, because they've either got indefinite leave to remain, or they've got, they are a British citizen. But your employee's visa may well be being, of course, being curtailed. They may have received a curtailment letter. They may not have received a curtailment letter. And there are, again, a lot of sort of things that you've got to look into sort of from a curtailment perspective. But if that is the situation, then again, that application has to go in really early. And a key point around sort of curtailment is that it is sort of the migrants' and responsibility to sort of update their address. So if the Home Office do not have your regular address, they would try to serve it at your address or an email address. And if that isn't served on the migrant, as long as they have then recorded that letter in their file, that will have taken effective service, and it's 60 working days from the point that they curtail the visa. So they give you a curtailment date. So that application has to go in prior to the curtailment date. And if as I said, if the person that's posted the question, if they are on, then feel free to sort of add any information that you need to.
Hi, it was me that posed that question.
Oh, hi, Karen.
Yeah, he's on an ICT visa, so he's over on I think it's kind of like a secondment, isn't it? So he's over with a company who work from India and working on a certain project, and I think it's that they were anticipating that project would last about 2 years, and now they're thinking it's going to be more like 2 or 3 months. So it's just that we have a sponsor license, and obviously it would have been ideal that I wasn't informed of the recruitment. I was sort of left out of it a little bit. So I said, if I'd known at the time, we probably could have gone through this and just sponsored her to start with, but she's already started working for us on this dependent visa. So I thought it did used to be that she would have had to go home, wouldn't it? You have to like do it out of the country, but she could still do it in the country now.
Yeah, so the rules have changed. So that's where the positive has come in. She can now make the application from within the UK. So again, only those that are here on sort of temporary sort of visas, and what I mean by temporary sort of visas are if the leave is granted as a visitor, if you're here as a sort of a short-term student, so under the short-term sort of category, if you've been granted sort of, temporary admission into the UK, or leave granted outside of immigration rules for particular circumstances, that's when you are then required to sort of go and apply from the country of your origin. If she's here as an independent at the moment, that application can be made sort of within. So if the partner's leave has been sort of shortened, what their sponsor will do is of course notify using the sponsor management system that the leave has been sort of shortened, and then effectively the curtailment of a curtailment date would be decided. And they would be issued letters. So even if that hasn't happened at that particular point, my advice would be to sort of get the application submitted for the worker.
Oh, no, that's really good to know, especially at the moment with people's travel problems and all that kind of thing.
Yeah, absolutely.
Yeah. Can I just ask one more question? It used to be they had a deadline every month, didn't they? Where they do the sponsorship, they do the certificate allocation on the same date every month. Can you apply at any time now? And it will.
Yeah. So again, so that's a different. That's what I was saying. So previously, what you had is you had the restricted certificate sponsorships and the unrestricted. Yeah. So I think you were referring to the restricted ones where you had to apply by the 5th of each month, and they made the decision on the first working day after the 10th. So the restricted ones are now called the defined certificate of sponsorships, which are only for the skilled worker category. And again, for those that are applying from outside of the UK. Now, if the worker is already working for you, so you're now going to be using what used to be the unrestricted, but is now described as the undefined. So again, you check your allocation to see if you have any allocated, for the remaining of the period that you've got. So if you held your sponsor license previously before 1st of December, then your allocation would run from April to April. So if you have any current allocations, you'll be able to assign the certificate of sponsorship to the person now. So it would be your undefined certificate of sponsorship that you would be assigning, which again, if it doesn't have it, be mindful though. So if you haven't got any allocations, they can take 18 weeks at that particular point. So if you're submitting a new request, it can take up to 18 weeks for undefined certificate of sponsorships, unless you then put in a request, so you have to pay extra for a priority.
Yeah,
service.
Yeah, no, that's really helpful. Thank you so much.
Anybody else got any questions? We've gone through the ones that have come through, so please feel free to ask anything. Suppose one thing that sort of coming up from what you've been saying, Ikram, is obviously once you've got a sponsor license in place, is the process now easier to follow? Is it more straightforward because there's consistency rather than having to go to the job market to understand whether there's a need for those skills? Or
yeah, I think in terms, I wouldn't say necessarily that it's easier. I think what's happened is that there are certain requirements that were previously there that have now gone. So in terms of certain barriers have sort of been removed. So it wouldn't necessarily make it easier, but I think that the process has been more streamlined. It can be quicker. But again, because of the whole Brexit thing, there have been a lot of applications that have gone in. So there was a huge jump from in number of approved sponsors within months. More than 60-70% have gone up from what were there for the last 10 years, people that became sponsors. And within sort of 5 to 6 months, there's been a 70% increase of employers becoming approved sponsors, which has sort of made sort of the work busier. There can be delays, and I think some of the key things for businesses at this particular time is also important to sort of look at. Are your sort of the quarantine requirements, the traffic light system, and other things such as red list countries? Businesses are thinking that they can't employ them because the terminology that had been used was you can sort of come to the UK from a red list country if, for example, you are a British citizen, you have leave EU national with sort of settled status, or that you have a right of residence in the UK. Now that terminology, right of residence, is very tricky because there were a lot of businesses that I was talking to and they said, well, look, they can't come over because they're on a red list country. A right of residence for that purpose is if you are issuing them a certificate of sponsorship, they do have a sort of right to reside and work in the UK. So by that terminology, they don't mean somebody who's settled in the UK. So again, for businesses, it was quite tricky, and the Home Office haven't even on that guidance, provided clarity on there. But yes, the processes are sort of, to answer your question, streamlined. But at the same time, I think the key thing, and I always go back to it, is making sure compliance element of it is very important. Karen just mentioned the example of an ICT, intra-company transfer. I've spoken to another business who in the past sort of used someone, and that category does not lead to sort of settlement in the UK. But they had a sort of a tick box exercise to say this. The system said to them, apply for an intra-company transfer visa. So the migrant was already in the UK. And then 3 years down the line of being on this particular visa, they realized that after 5 years, I'm not going to qualify for indefinite leave to remain. So that's where getting that advice is very important. Assigning the correct certificate of sponsorship is important, because if you assign a wrong certificate of sponsorship, the guidance by Home Office is very clear that they will revoke your license, because what they're then saying is if you don't know which certificate of sponsorship to assign, so if you make a mistake in that, then you're not familiar with your duties. So as well as sort of, processes being sort of simplified, it's very important to sort of stay up to date with knowledge, or get that legal advice right at the start, so you don't end up sort of, going down the wrong path, because there can be sort of bigger consequences.
Thank you. Is there anybody else who has any more questions or anything they want to raise, or even discuss the problems they've had with the application process, or understanding around sponsorship license applications? Obviously dealt with it all, Ikram. Is there anything else that's coming up from your perspective? Anything that there's a trend in people raising concerns, or anything that the Home Office are coming out with that might be useful, as in need to know information?
Yeah, so sort of two things. One, if you are sort of employing EU nationals, because having dealt with a lot of sort of personal immigration previously as well, I've had sort of a number of people sort of calling me up and asking, because if they have been granted status under sort of the EU settlement scheme, or if it's pre-settled or settled status, they are now allowed to sort of be absent from the UK for a period of between 2 to 5 years, depending on which status they've got. And so current employees that are either on furlough or even already working, they are now considering at this particular point to sort of go back to the country of their origin for that period of 2 to 5 years, or at least until things settle down, because they're finding costs are a lot higher. So I think challenges for businesses in that perspective are going to sort of come up to find the right sort of employees. So again, we've had, and you'll know that we've had discussions with sort of restaurant owners, bar owners, and other sort of sectors that actually have chefs and other staff. The construction industry are sort of finding that challenge, and other, of course, industries as well. So where you have that, this is something to sort of keep an eye on. And when I say the need for a sponsor license, is sort of to look at if there has been a reliance on sort of EU workers, then there is that consideration that are they considering going back, because this is not something that they're going to tell you. It may just be a case that they've got a 4 weeks notice, a month's notice, and they come up to you and say, I'm now leaving. So you're then left with a task to sort of, recruit somebody within that time. So that need for a license, if it's going to take 8 weeks, these are things that businesses really have to sort of consider and have that in place as a precaution. Because overall, what I will say is that the cost, when you weigh it up, there are, of course, other costs associated with sponsoring the migrants. But if you're a small business, £536 over the period of 4 years isn't a particularly high cost, or 1,476 isn't a high cost, considering the potential, harm it can do to businesses. But again, I think it's looking at each sector and where they are. But I'd be sort of almost considering, more than the usual need, is there likely need for it? Because a lot of businesses are sort of shifting towards applying for it.
Yeah, that's one thing I've noticed. There's a lot of hospitality. It's coming up a lot in the hospitality sector. There's a lot of stuff. People lost a lot of waiting staff, but it doesn't appear to be that widely known when it comes to chefs and other things. So I don't know whether there's a lack of knowledge in the sector about it that's causing it. So Anyhow, unless anybody has any more questions, anything else you want to add, Ikram, and then probably finished 5 minutes early, 10 minutes early?
Yeah, no, that's pretty much it. Really, I think there was actually one question we were discussing, something that came to mind, and a recent sort of a good example again on compliance that came up with somebody that are now looking to apply for a sponsor license, but in the past they'd obviously lost. They had a revocation of their license in the past, and that was purely for a reason that they'd sponsored a migrant worker and were paying roughly close to the minimum salary mark of what they were required to pay. So they sort of sought advice around sort of employment law, and then because the person was off ill, and then ended up paying statutory sick pay, which they were entitled to do, of course, under employment law, because the salary then dropped below the minimum requirement for the annual period. Not only did the migrant was refused their next application, it sort of got triggered at that particular point when this information came through. The company ended up sort of losing their licenses again. So again, goes back to having that knowledge of wider sort of UK law, but at the same time getting advice from the right person, because they were completely right in terms of doing what they did from an employment law perspective, as you would know. But from an immigration law perspective, it resulted in them losing their license.
So, okay, so then the salary banding applies irrespective of circumstance, so that they need to earn those those earnings to comply with the terms of the license, okay, so that's interesting, because that's obviously from a risk perspective, it's quite relevant, because obviously companies, if you bring somebody on, you've got to be aware and alert to the fact that if they go off sick for 6 months, then those costings have to be built into your process, and obviously, unfortunately, the company would have to swallow it. I hadn't appreciated that.
I mean, again, the duration that you mentioned, sort of from a 6 month perspective, and I know from an employment law perspective, this is where contracts are important. But if you had somebody off from a 6 months perspective, again, you're going to be looking to sort of change somebody who's going to come in. You're going to put somebody in their place. But this was for a shorter period of time. But because they were bang on sort of on that mark, even a period of absence of 2 weeks took them below the required threshold. So
would that have been the same if they'd been furloughed? Because obviously furlough would have brought their earnings below, or has there been an exception brought in for that?
Yeah, so again, there were specific sort of provisions in for sort of furlough period, and that sort of discussion came in around what needs to be done. Can they potentially be furloughed? So there was, again, conflicts of information initially that, yes, you can furlough staff, but where you have the conflict with sort of immigration laws is that if staff that was being furloughed really were staff that you didn't need at that particular time or didn't have workforce, if you've sponsored somebody under sort of the provision that they are required to come and do a particular job, if that job is no longer required, then you end up cancelling their leave rather than putting them on furlough. So it's quite an interesting sort of a differentiation that you've got with staff that you would furlough. And if you're sponsoring somebody to say that you need them for a role, well, if that role is gone, then technically you're no longer sponsoring them, and the government wouldn't be willing to pay for somebody who's a migrant worker.
So has that been a pitfall that a few businesses have fallen into?
Yeah. So again, and then that's
COVID, because essentially it was we were reading it as it was brought in, all the queries and issues around holiday pay and accrual of holiday and payment of holiday and all sorts of. It was all rather mad. So I imagine quite a lot of companies have fallen foul of that.
Yeah, and I think some would have fallen foul and would have applied for the furlough scheme. And at that particular point, I haven't seen too many examples, but I can imagine that some would have got picked up and they would have realised that they're not eligible for furlough. But again, if that's happened, that's going to be quite an interesting point for some. I did do we discussed this in a webinar earlier in the year to say, when the furlough scheme came out, to say if you are sponsoring somebody, then what you need to do and what you need to be sort of mindful of.
Great, perfect. Right.
Brilliant. Yeah. So if there are any sort of questions that have arisen from what I've sort of said, if it's something that I haven't sort of discussed today, feel free to sort of and drop me an email, contact me by telephone. Helen, do we have those details to be shared, or I can sort of send them out separately? Again, I'll send out some emails. So if there are any sort of specific questions, more than happy to sort of have a one-to-one chat and of course answer any queries.
Perfect. Thanks, Ikram. Well, thanks for joining us today.